Hi, Michael Bachelard here. I'm the host of Diagnosing Murder. Since the podcast went out, we've received a huge response from you. A lot of people telling their stories. And the more I hear, the more I realise this story isn't over. So I'll continue reporting on this issue. In fact, we're working on a bonus episode right now about another extraordinary case. So stay tuned for that. In the meantime, here's a behind-the-scenes interview I did with Professor Xanthi Mallett and Tim Watson-Munro. They're the hosts of true crime podcast Motive and Method. And in it, they've turned the tables on me. They're asking the questions. Till next time.
You've got years of experience under your belt as an investigative journalist. For our listeners, can you give us a bit of a resume?
Boy, well...
Big question, I know.
I've been a journalist my whole career. Started as a copy kid at the Canberra Times back in the early 1990s. I've been a foreign correspondent, the Indonesia correspondent. I've been an investigative reporter since 2006. I edited the investigative team. So a lot of that behind-the-scenes stuff for Nick McKenzie and some of those legendary investigative reporters, I was the sort of editor on those stories. I've edited the World section, I've deputy edited The Age, and then ultimately I decided actually what I really wanted to do was report. So I came back to reporting about 3 years ago.
I recall, you have a fabulous reputation, but I think we first met, and I'm not sure if we can mention this, but you interviewed Xanth and I over the Robert Farquharson case. It's subject to ongoing investigations and a possible appeal.
That's right. Yeah, a couple of years ago, one of the things, I came out of editing with a few things I really wanted to look at that I'd known about, were around for a few years, and the Farquharson case was one of them. And what I thought were serious questions over whether that conviction was sound. And I found my way to both Tim and Xanthi in that
Poor bloke.
in that process. And yeah, we produced a podcast about it a couple of years ago.
Yeah, I really enjoyed working with you at that time. So, Michael, Diagnosing Murder is your latest investigative podcast. Was there a specific case that drew you into this issue of shaken baby syndrome? Or what was it that prompted you to start looking at the topic?
Well, again, this was something that I'd known about for some years, and as an editor, I got one of our investigative reporters to look at it, and he covered a court case here in Victoria in 2021, which was a second and subsequent appeal in a shaken baby case. That's the Jesse Venassia case. That went to a full court of the Victorian Appeals Court. Yeah. And they ruled against Venassia and said it was a majority decision, 2-1, and they said shaken baby syndrome's a real thing and this guy should be in jail. And for me, it's that's been unfinished business. I felt like we hadn't really had a proper investigation journalistically of the science behind shaken baby syndrome, the politics around it, and the kind of some of the cases that have come up. But I didn't want to do it. I didn't want to make another podcast about dead children, frankly, after the Farquharson case.
No, I get that.
And I didn't want to be that guy. But then I went to a meeting about this time last year, and I heard about this particular case. It's the case we cover in the podcast. We've given them the names Kabir and Deepika. It's a couple who at that time were facing criminal charges for recklessly causing serious injury to their child, who we called Dua. And the case was live. It was current. They had lost Dua for 18 months to foster care. Kabir was confronting a criminal case and potentially up to 15 years in prison. And they were willing to talk. And as a journalist, that is an incredibly rare combination. They were willing to talk on tape. And I just thought, well, I don't want to do this now, but I can't pick the timing here. I just have to jump on this case.
And that's episode 1, as I recall.
It goes through the podcast, but episodes 1 and 4 really look closely at that case.
And so I heard the despair in their voices, having listened to those episodes. it's real for these people, isn't it? And this is not a child who died, but it can be more serious where children die. There's been cases overseas where people have been sentenced to death on the basis of perhaps dodgy evidence regarding shaken baby syndrome.
This reminds me very much of Meadows' Law. You know, the 1 child death is sad, 2 is suspicious, and 3 is murder, which we've talked about in relation to other cases on the podcast. You know, Professor Soroy Meadows came up with that ethos, and you know, its shadow was across a lot of cases, and the same with shaken baby syndrome. But before we get into what you found across your investigation, can you just give us a snapshot of what shaken baby syndrome is, or at least what the classic diagnosis would be?
The classic diagnosis of shaken baby syndrome begins really with 3 medical signs. One is subdural hemorrhage, so that's bleeding under the dural layer of the brain. It's one of the layers of the brain. The second is retinal hemorrhage, or bleeding in the light-sensitive layer at the back of the eyeball. Yep. And the third is a variety of symptoms or a variety of medical conditions, but essentially swelling of the brain. And if a child comes into a hospital and has one or more of those signs, clinical signs, it's been held since really the 1970s, but in a kind of judicial and legal sense, probably since the 1990s, that might signal a criminal act of shaking. The diagnosis itself has morphed over time. They tend not to call it shaken baby syndrome anymore. They call it abusive or inflicted head trauma. They add the words with or without impact because they sometimes say that perhaps there was impact involved, whether or not there's bruising. But either way, it's these symptoms or these signs that kind of seem to lie behind that diagnosis. And of course, since probably the 1970s and 80s, there's been a law in most states of Australia that you must, if you're if you're a physician or a paediatrician, you have a responsibility to report. It's a mandatory reporting responsibility to take it to child protection. And the child protection people might take it to the police. And so you get this kind of cascade of responses that come up once a child, particularly a small child, a baby, appears in hospital with these signs.
The system takes over in a way. It reminds me of a case I did, nearly 40 years ago. I was very green. I'd just come to Melbourne from Sydney. And it wasn't the case of a dead baby, but it was a case of a woman who had had her child taken by community services, as they were known then, on the basis of a diagnosis of Munchausen's by proxy.
Oh, rare.
Now, that's a very, very rare condition. And the backstory to this case was that she had tragically lost a child to sudden infant death syndrome. She was understandably anxious about the welfare of the newborn. So whenever the child had a sniffle or a rash, she would take it down to the hospital. And eventually they said, well, you've been here a lot. Long story short, she was diagnosed with Munchausen's by proxy, but the process, in terms of what you're describing, was very similar. The lawyers did a backtrack on the evidence forensically, and they found the initial case notes when she'd first presented, and it was a social worker had written Munchausen's by proxy ?
And that was how she became, quote, diagnosed?
Well, that
started
it went up the food chain, if I could put it that way, like a Chinese whisper. So by the time it was put in front of a paediatrician, it was a well-established fact that this was a very rare case, but a legitimate case of Munchausen's by proxy. The result of that case was she took them on. There was evidence led to say this was nonsense. I can't recall the statistical prevalence of Munchausen's by proxy, but it's exceptionally rare. And her child was returned to her. What she suffered at most was an anxiety disorder based on tragedy. So this process does go on all the time, it would seem, in varying iterations.
Yeah, I think it's a really pertinent example. And what happened in the case of Kabir and Deepika, and I've heard it happening in other cases as well, is that the diagnosis is made and that sets this cascade of events and interventions in train. And then the parents are asked with intent what happened to the child. And from their perspective, Kabir and Deepika's perspective, the child just went limp one day. They don't know. They're waiting for a medical explanation as to what went wrong. So when they're asked what happened, they say the child just went limp. But that's not an explanation that satisfies the people asking the question, the forensic paediatricians and child protection and the police. What they want to hear is, I shook the baby. So you're kind of in this catch-22. You either say, I shook the baby and satisfy their question.
Confess and avoid.
Confess and avoid. Or you say, I don't know what happened, and you're essentially lying about what happened because they already know what happened.
So you're guilty until you can prove otherwise. And obviously in this context, you can't prove otherwise because there could be any number of reasons why a child would present with those symptoms.
Right. And, I mean, medical science is still puzzled about many of the reasons why children get ill, have seizures or die.
You've spoken to medical experts who are now disputing, we'll call it shaken baby syndrome. What do they say to you?
Well, probably the key expert that we've interviewed in the podcasts, and it was, I was so pleased to have got him because he's an incredibly credible voice in this space, is Stephen Cordner.
Oh, yeah.
The former head of Victorian Institute of Forensic Medicine for decades. And he's become very concerned about this diagnosis. And he says, you know, the more we learn about babies and children, the less we know. The things we were certain about a decade ago, about, say, fractures, for example, were signals of abuse, may not be, because there are a bunch of genetic conditions and other medical conditions that might cause those. He says there are 40 to 50 known medical causes that could be associated with aspects of the triad symptoms. 40 or 50 known ones. And then he says there are those that we don't know.
So 40 or 50 different reasons why those symptoms could present that do not reflect intentional shaking or a child abuse, in essence.
That's right. 40 or 50 conditions which a parent is being asked, well, what went wrong with your baby? And they say, I don't know. That could be an absolutely legitimate answer.
An alternative that has nothing to do with shaken baby syndrome.
That's right. And you know, I guess that's the basis of his concern. In the Kabir and Deepika case, without giving any spoiler alerts, Cordner provided an expert report to the defence, which was then passed on to the prosecution, which said that he thought it was baby Dua's traumatic birth. She was out, you know, second stage labour was like, you know, less than a minute or a couple of minutes. The mother had a 4th degree tear. She described it as being, the mother, Deepika, described it as being from the vagina to the bumhole. This was a traumatic birth.
Yes.
But in the prosecution, it says, no, birth was normal, didn't recognise this at all. And Cordner said you can't rule out that caused a traumatic bleed in baby Dua's head, which would explain two things. It would explain why she had a seizure and collapsed, but it would also explain why she had been such an unsettled child up until the point of that seizure, to the point where she'd been in hospital, and to doctors with the parents saying, why will this child not lay flat? Why do I have to hold her the whole time? All this was on the medical record, but the forensic paediatricians diagnosed shaken baby syndrome at first sight.
Well, it asks a third question in my view, and that is, why did the prosecution sort of skate over that obvious medical fact? I would have thought, I'm not a doctor, of course, but common sense dictates that it's relevant. Why would you say it was a normal birth when it completely was not a normal birth?
Well, if you go through the documents, and I've been through them, it's kind of downplayed a little bit, that birth trauma. But they can't say they weren't told that Deepika was very upfront from the beginning of Dua's arrival in hospital about what the birth had been like. But that was coming from the mum, and the mum was under suspicion. And there's a tendency, I think, to think that parents can't be believed.
But there's medical evidence that she suffered a major vaginal tear during childbirth. You can't make that up. If it's on the record medically, I wouldn't have thought. What do you think, Xanth?
Oh, yeah. I mean, you see this a lot, though, don't you? If something doesn't necessarily fit a narrative, it gets kind of diminished. And I think you're right. I think there is sometimes a skepticism about what parents say. People assume parents don't know what they're talking about when they talk to medics, that, you know, their experience of a situation is kind of less relevant than the medical opinion. And I think, you know, these people know, they were there, right? And yet their experience of that is diminished in that story.
Well, we've discussed many times, Michael, the issue of confirmation bias.
Yes.
Where you set out with a point of view and you look for evidence that confirms that and exclude all other evidence.
Yep. That happens well, we know that, right? Miscarriage of justice, one of the key reasons it happens. Tunnel vision, confirmation bias. Yeah, it happens.
That exact thing was writ large in this case. We have a massive cache of documents thanks to various people who intervened for Kabir and Deepika. And among them, you can follow the train. The police investigation goes out and starts looking for signs of domestic violence. So, for example, they see a bedhead in one of the bedrooms in the house. Now, Kabir says, I dropped that bedhead one time when we were moving. It's an IKEA bed, you know, and damaged it.
It happens all the time, right?
Right. But in the police evidence, this is logged as a, quote, fist-sized hole directly above where Deepika's head was. It's not just a hole, it's a fist-sized hole.
Yeah.
They were also suspicious that, you know, the baby's clothes were soaking in a sink rather than in the washing machine. They were suspicious because the cot mattress was too short for the cot. Like innocuous things led to their suspicions. And so their diagnosis based on these kinds of things was that he was perhaps a coercive, controlling domestic violence perpetrator.
Yeah.
Completely disbelieving what Deepika said. In fact, follow it through.
Because she's being controlled by him.
She's being
right?
controlled. So follow that through to its logical conclusion. You end up with two reports by domestic violence practitioners who say, firstly, well, the main problem still is that he won't admit to these injuries that we know existed because. And she won't admit to being coercively controlled because she's coercively controlled. So perhaps the solution to that is to put him in prison so that she will finally feel free.
She'll see the light
to
and
admit
tell
it.
the truth, right?
Now, you know, I mean, I don't want to diminish coercive control, and I certainly don't want to diminish domestic violence.
Or the fact that shaken baby syndrome, in some cases, is real.
Well, there is actually a good big scientific debate about that too.
Yeah, that's why I threw it in.
And we spend a lot of time.
Michael.
We spend a lot of time in the podcast talking about that. But nevertheless, I guess the point is that if you can listen to Kabir and Deepika talking about their lives to each other, interacting with each other in our podcast, and I guess you get to hear as to whether you think she's so subdued that she's being controlled by him. As for does shaken baby syndrome exist, well, that really is still a massive source of conjecture.
But some people do abuse their children and do shake them, and it does cause trauma. But are you saying that the symptoms that have been identified as reflecting shaken baby syndrome are what is contested?
Right. And I don't want to for a moment diminish child abuse. It absolutely happens and is horrific. And the state does need to intervene in cases of child abuse. But can shaking a baby cause retinal hemorrhage, subdural hemorrhage and brain swelling by the act of shaking? There is doubt about that. And the doubt really centres on the science. You can't shake a baby to find out. So the evidence is anecdotal and based on confession studies. And Kabir said to us at one point when Child Protection was saying, well, you know, Dua, the baby, can come home if you confess, essentially. And he said, I was tempted to confess.
Oh,
I wanted
to get the baby back.
To get the baby back, to get the baby out of foster care. And he said, well, I'll lie if you want me to lie. And they said, no, we don't want you to lie. And he said, well, I didn't shake the baby. But this goes way back to experiments that began in the 1980s, biomechanical experiments which have been done repeatedly with baby lambs, baby monkeys, dolls, crash test dummies, and you can, as violently as you can possibly shake a baby-sized crash test dummy, the amount of force you exert on the inside of the baby's head is a tiny fraction of the amount of force that a baby that is inflicted from a fall, even from something as low as a couch onto a hard surface. So an accidental fall could explain a case like that. So the biomechanics have been unfriendly to the shaken baby theory. You can't do the experiments to find out, and when you look at witnessed cases of shaken baby syndrome, cases where somebody's been witnessed doing the shaking, you don't tend to see those symptoms. You see other damage, but you don't tend to see the triad, except, in cases where the baby has a pre-existing condition. So I think that's partly why the diagnosis has morphed now to you need, maybe there's been impact that we don't know about. There's no bruise, but it could have been impact. But that debate remains live. The debate as to whether it can even cause those signs, clinical signs, is actually a live debate.
Well, you've tapped into something that's very relevant at the moment in terms of potential miscarriages of justice. As you say, of course, child abuse occurs. Children need to be protected. But we need to look at what's going on with the system, the gaps and the failures. What did you find? How do you think it can be remedied?
That's such a difficult question, Tim. And, as a journalist, I'm good at pointing out flaws.
Yeah.
Probably less good at pointing to solutions. We didn't really cover this in the podcast. I'm actually thinking about doing an extra episode on this, but it seems to me that in the child protection system, that is before you get to the criminal courts,
yes,
and where you're in the children's court kind of arena, there's a tendency to play it better safe than sorry. And that is, if a child comes in with these signs, if a forensic paediatrician says it's likely non-accidental injury or abusive head trauma, then that report carries very often sufficient weight for both defence and prosecution in that case to say to the children's court magistrate, we better be safe here and remove the child. And I've spoken to practitioners who say that's kind of how it works. And the child might be away from home for 18 months or 2 years in foster care or in family care.
And that's a separate discussion about the potential damage to those children, referable to bonding between the child and the parents. And I hate to say it, the potential abuse that occurs with some kids in foster care. I hear about it all the time in my practice.
Yeah. And perhaps I will interview you for that bonus episode because, I think it's better safe than sorry as well. You'd better be sure that the diagnosis is good and that they are safer where they're going than they would be where they've been. As for the criminal courts, look, I think we come back to that question that you guys have talked about a lot and that I've talked about in my previous episode on the Farquharson case, which is, how reliable is the science that we are deploying in court? How reliable are the experts? What kind of questions are we asking them? And Cordner, for one, wants an inquiry, and he's not the only one, into the reliability of the science of shaken baby syndrome in Australia. And he wants to ask that question so that the people who are giving evidence for the prosecution in these cases are held to a scientific standard of proof. Not
just I reckon.
Not just I reckon. And not just based on this is what I was taught and these are the authorities. Are the authorities right? Have the authorities been questioned? And, there is a growing body of medical science globally that says we're not sure about the shaken baby diagnosis. And in the US, for example, you mentioned that there was a guy on death row in Texas. His name's Robert Robertson. He was days away from execution in October, just recently, when the appeal court in Texas says, hang on, we're not sure of the science here. We think it might be junk science, and sent it back to the appeal court for another appeal. He's been on death row since 2003. And there are a number of courts now in the US that won't try these cases on the basis that they believe it's junk science. So things are moving globally.
But that's a problem in itself because, as we said, children are sometimes abused. Now, I'm not saying that these particular symptoms that have been listed as reflecting shaken baby syndrome should be relied upon, but there will be cases where children have been shaken and damage caused, they've been injured. And there may now be a reluctance to try any case where there's a doubt over it because of the shadow of these problems. Does that make sense? So genuine cases may not be taken to court because of this ongoing issue. It's a double-edged sword.
That's absolutely right. And that's why it's such a diabolical issue. As I say, I don't have a solution to that. I think Cordner's call for an inquiry is a very sensible thing. What can we reliably say about the science here? And going back to my previous podcast again, Anna Maria Arabia, the head of the Australian Academy of Science, and the Academy was very involved in the Folbig case, said we desperately need in Australia two things. We need a reliability standard for the science that's used in courts.
Which is amazing that we don't have that. We have admissibility standards in other countries, but here it's much more laissez-faire, shall we say?
So the science your expert is talking about, there's no requirement on them to prove that this is reliable science. And she said we also need a criminal cases review commission to look at these potential wrongful convictions.
Yeah. Absolutely, we do. Yeah.
One of the things that's really shifted the dial in the US are the innocence projects.
Yes.
They've had 40 exonerations in the US on shaken baby cases because of the work of innocence projects. We just don't have innocence projects in Australia.
Yes, we do.
Well, not in the same way, though.
Well,
the learned doctor's part of one, aren't you?
Yeah, I started one. But we haven't had any exonerations yet, partly because, and none of them, there's one in Sydney, there's one in Brisbane, there's one at Newcastle University, one down at RMIT, down in Melbourne. So we do have them. Innocence projects exist. But the problem with the cases is, it takes a bloody long time to work through them. These are not done overnight. Getting documents is highly problematic. There's no money to support the evaluations and to get expert evidence. So they exist. And there are people very committed to working on these miscarriages of justice. I know because I work with them. And yet, there are still so many cases that, don't have access to those types of resources. And we desperately need a criminal case review commission in this country as a port of call for people who are claiming to have been wrongfully convicted.
As somebody who knows about the ongoing attempt to mount an appeal for Farquharson's case, that's absolutely true. There's a bunch of lawyers working hard but pro bono.
Yeah.
The client's in jail, has got no money. They seriously believe he's an innocent man. He's in jail for 33 years. But getting that to the door of the court for their second and final kind of chance is a massive undertaking that they're doing for free in their spare time.
Yeah. And that's the thing.
Good people do exist, right?
Yeah. And that's the thing. People need a champion on the outside. That could be a journalist. It could be an innocence project. It could be a family member, a lawyer, someone, though. They all need a champion because when these people are incarcerated, they don't have access to any resources to assist them. They can't do the legwork. They don't have the skills, don't know legal systems to do it. And if they don't have that champion, that's what worries me, those people who are silently sitting in prison, wrongfully convicted, and they don't know where to go or how to ask for help.
Which leads into another question. What does this mean for previous cases, people have been convicted over these shaken baby syndrome diagnosis. I agree with Professor Cordner. We need an inquiry. I agree we need independent analysis of all this. Let's say all that gets up. What then happens to these people who have been potentially wronged by the system to date?
Well, what happened in the UK is interesting. There was an appeal, I think, I'm slightly sketchy on the history here, but in general terms, there was an appeal which overturned a shaken baby case and questioned the science. And the Crown Prosecution Service then sort of got a judge to have a look at the science, and the judge found there were some questions over it and looked at a whole bunch of previous cases. And out of that, essentially, the judge found that most of them were sound, but the Crown Prosecution Service came out with a new policy around what they call triad-only cases. These are cases where the triad of symptoms and signs, the three that I spoke of earlier, are the only diagnostic method of saying this baby was shaken. There's no bruising, there's no head injury, other head injuries, there's no fractures and so forth. And they said the Crown Prosecution Service adopted a policy to say, let's be very careful about those cases, essentially. Let's look outside the triad to see if we've got further evidence or proof. Now, that's, I think, that's a useful recommendation. I think that some of the advocates would say that doesn't go far enough, but nevertheless, it's at least, something. But in Australia, we've had a bunch of triad-only convictions. In Victoria, particularly over the past sort of 8 years or so, there's been quite a lot. Kabir and Deepika's case was 1.5 elements of the triad were there.
So you don't have to have all three necessarily.
You don't have to have all three.
It's very dangerous.
There was no brain swelling in Dua at all, and Dua made a full recovery within days. So there's one case I know that I also feature in the podcast, a young guy called Jesse Harvey. He's served his term now, 6 years in jail. But his babe, I think there's holes all over that conviction. It was basically on the medical evidence only. It was a triad-only case. But up until 48 hours before his baby had a seizure, he was in hospital with a swollen head, with fever, and it turns out the child had a congenital heart condition, and that the mother had a seizure disorder and epilepsy through into adulthood.
So there's some genetic connection potentially.
Which, as a child, had led to a diagnosis of shaken baby syndrome, and she and her sister were put into foster care. So
that's an extraordinary case.
All of that happened. None of that was raised in the case, even by the defence. And the defence argued, well, okay, the baby was convinced by the medical diagnosis. Okay, the baby was shaken. Maybe it was the guy's brother who did it. Completely didn't convince the jury, and he was convicted and spent 6 years in jail.
So did the child die?
The child eventually died, but at the time he was tried and convicted, the child was alive, but living with permanent disabilities,
right, okay.
And died of his injuries a few years later. So, to me, the medical, like the reasonable doubt in that case is just a blaring
drive bus through it, right?
Right, but he spent 6 years in jail. I've spoken quite a few times to Jesse. He's a young, uneducated, very smart, uneducated kid from a very poor background, and he didn't stand a chance.
Yeah, he was railroaded by the sound of it. And of course, it's not just the deprivation of liberty, is it? It's spending time in jail as a convicted child abuser.
Yeah, the stigma you carry with you for the rest of your life.
The stigma, and inevitably placed, I'd imagine, in protective custody. That sort of escalates the intensity of the prison experience, if I could put it that way. It's highly traumatising against a backdrop of potentially being innocent. It's extraordinary.
It will also affect every relationship he has. If somebody dates him and they have children, that could cause problems, with friends, with family. It goes on and on. The impacts are just endless.
Well, you're labelled for life, aren't you?
Yep.
Really. It's something you carry with you, whether you're guilty or not.
Yeah. And, he's found it very hard to get a job. He's still got... there are things that still prevent him from hanging out with children, and he's got nieces and nephews and people in his family and things like that, people he can't see because of that. It's got a long tail.
Absolutely.
Yeah, absolutely.
Well, it's been a fascinating discussion, and spoiler alert, I've listened to a fair bit of this podcast. It's worth listening to. It's fabulous. So, Michael, congratulations again on a fabulous job well done. And thanks for joining us today on Motive and Method.
Thanks so much, Michael.
Thanks very much. It's been a pleasure.